Data privacy protection is a relatively new field in the country, with the Nigerian Data Protection Act signed into law on June 12, 2023. To further acquaint stakeholders with the operations of the data privacy protection law, the Nigerian Data Protection Commission has put together this workshop aimed at validating the general application and implementation directive of the Act. Participants are drawn from across various fields, including government, ministries, departments and agencies, the organized private sector, and the security services. The National Commissioner of the NDPC, who is the keynote speaker, explains the significance of the event.
Incorporating the views of our stakeholders to ensure that we cover, although we will have more than 100, 200 views about issues. So we look at the relevance of the inputs and the value that such inputs will add to the document that we're trying to prepare. Because the most important thing that after producing the document, if it is released as our own guide in Nigeria, it should get to anywhere and be able to stand tall.
It provides a context into how the law should be obeyed. That is what we are also doing today here, to do a validation workshop. The validation workshop itself is one of the continuum of measures and steps that we take to follow our rulemaking process. We want stakeholders in the country and even outside Nigeria, because of cross-border data flows.
As far as the protection of data privacy is concerned, the legal enforcement team of the NDPC confirms that Nigeria's laws rank among the highest in the Global Best Practices Index, with very stringent penalties meted out for infringements.
So the law recognizes that if you are a data controller of major importance, for instance, you may pay the higher standard amount, which could be 2% of your gross annual revenue the preceding year, and it could be 10 million naira, whichever is higher.
Officials of the NDPC's legal enforcement team walk the workshop's participants through the nitty-gritty of the NDP Act's General Application and Implementation Directive.
Is there a public interest for us to keep this data? The people need to know that this kind of precedent exists. For example, maybe the president is a pedophile, and that sort of offense is quite grievous. So the whole thing, wouldn't we want this to still be out there so that people can know who this kind of person is? So those are things that the court will consider in relation to right to be forgotten.
The question and answer session that follows is meant to collate and aggregate the contributions of stakeholders towards further strengthening Nigeria's data privacy protection laws. It remains an ongoing process. Charles Eruka for Arise News.